Here we go.
WDXE News, on the air since 1951. This is the legend. 105.3, 95.3, WDXE.
And it's Friday, and it's time for Stan Pierchoski and Bulletproof Estate Planning here on WDXE. Good morning to you, brother.
Good morning, Jeff.
Yeah.
And if we've been on the air since 1951, we're getting tired.
Boy, are we tired.
Yeah.
Since 1951, yeah.
Anyway, this is Bulletproof Estate Planning every Friday at 8 o'clock in the morning till 9 o'clock, where we talk about, excuse me, estate planning. You know, I don't have to clear my throat till I get on the air.
It happens to me, too. It happens.
But, you know, we do this show. It's a call-in show. I got a couple topics I want to talk about today, but you can call in anytime if you want to, ask a question, certainly, or share an experience.
Yeah.
Or just, whatever.
I've had a text question to me to ask you.
Great.
So we'll talk about that in a little bit.
Always starts things off, but let me just hit some of the stuff we always talk about is we have a seminar coming up. Now, my seminars are pretty popular, and we get a pretty good turnout, and that's something I want to talk about, some of the questions I get. But the next one, we actually do these about every other month. We used to do them a little more frequent, more like 6 weeks, but now it's about every other month. And the next one we do, remember the last one we did was on the day of the ice storm, and it came in and we had to punt it a week to the next Saturday, but we did it over in Pulaski. So the next one is March the 28th, which is a Saturday. We do Saturday seminars at 10 o'clock in the morning. We call them Will's Trust in the Nursing Home, and that's going to be right here at the back of the building on WLX at the Country Cafe. So I'll bring that up again at the end of the hour, but that's the next seminar coming up. It's not too early to RSVP for that, simply because we had a good handful of folks that could not make this. Well, we canceled the one when the ice storm hit, but not everybody could make the very next Saturday. So a lot of people just decided to come to the one in March. So we've already got people signed up for that, but it's a pretty big venue here, so we don't have too much trouble making sure we got everybody.
Yeah.
So I'll bring that up again at the end of the hour. So
Yeah.
Well, I think maybe the best way to start out is with your question.
Well, it's an estate question, but also a tax question.
I'll see what I can do.
And so I'll kind of pre-warn you on that. It has to do with the step-up capital gains tax, and can it be avoided? And here's a circumstance. Someone had a farm worth $1 million in 2023, and that same year, I think the husband dies. And then evidently, if I understand this right, the wife is left behind but needs to sell the farm, but now it's worth $2 million. Okay. So, but it's worth $2 million. So what they're saying is she's evidently going to have to pay a capital gains tax of 15% on that million. The spread between what it was worth when he passed and what it's worth, which is called the step up. We've talked about this in brief before, but we're saying, okay, can this be avoided?
Well, sounds like you're referring more to a step up in capital gains tax.
Yes.
When the step up really applies to the step up in your tax basis.
Yes.
So now it can be kind of complicated. But
it is a little complicated.
Let's look at it from a fundamental standpoint where it's easy to understand, then we'll extrapolate it to their circumstances.
Uh-huh.
And if you have those folks, husband and wife, own the farm, right?
Correct.
So if you own a piece of real estate, you have what is called a tax basis. Basically, it's what you paid for it. I mean, that's a pretty good guesstimate of what that's going to be. So let's say they paid $500,000 for this farm 20 years ago.
Yeah.
And now it's worth $1 million. Okay?
Right.
Let's go back to before the one spouse passed away. So it's worth $1 million. Now, if they sell it, they're going to have a capital gain of $500,000, right? And that's the difference between their tax basis and the fair market value that they sell it for.
Right.
Now, that's the capital gain. Now, there may not be a tax due. The tax is only due on the gain if you realize the tax. And realizing the tax means you still have the money 6 months later or 180 days later. In other words, if you buy another piece of property and roll that money into that, you can kick the can down the road on the tax.
Yeah.
That's the gain. But just because you have a capital gain doesn't mean you owe the tax yet. But if you keep the money, then you're going to owe the tax. All right.
Okay.
Now, so let's say it's $1 million and the husband passes away.
Yeah.
It goes to $2 million. And then the husband passes away. They kind of look at that. Well, let me back up. Let's say you go to the second death.
Yes.
At the second death, if they leave that $2 million farm to their son,
Yeah.
the son gets a step up in tax basis. So the person that inherits it, his tax basis is now $2 million, the fair market value the day of death.
Okay.
Which means if he would turn around and sell it the very next day, no capital gain at all. But if he kept it for a while and it got to 3 million, then he'd have his own capital gain, but started from the stepped up number.
Okay.
Now, when you have a spouse pass away of a couple in capital gains, they look at property as if it's half and half. It's not really half and half ownership, but for capital gains taxes, half of the capital gains have been stepped up at the first death.
Okay.
And the second half gets stepped up at the second death, and that's why the son gets a full step up in basis for the entire property. But if she's going to sell it, her capital gains will be less than than the son will get, but it will be more than if they, or less than if they had sold it together. See what I mean? So,
Okay.
in other words, there's already some step up in basis for the first death.
Okay. Now, I'm trying to digest this. It is a
Okay.
little complicated,
Well, it is
but so you
numberhead.
got a husband and wife, and let's say this is me and my wife, for instance, and God forbid something happened to me, tomorrow, and a year from now, or 2 years from now, however long down the road it is, Teresa decides to sell our farm and property. So if I'm understanding this right, the property is given a value at my passing. And then when she sells it, if there's an amount above that, then there's some kind of tax on this.
Well, one thing I do not think is accurate, but again, I'm not a tax attorney, but I don't think is accurate is the valuation of the property at the first death. I don't think that happens. What happens at the first death is half of the capital gain that exists steps up. And so she's gonna have a capital gain basically on half the value, whereas instead of the whole value.
Okay.
Because of the first death.
Okay.
The value is the value at sale.
Right.
There's no gain in the value of the property. So maybe a better way to look at it is if it doesn't increase in value.
Okay.
Okay, so you buy it, you have this tax basis. Let's say if the two of them decide to sell it, they have a capital gain of $1 million. If one passes away and the survivor sells it, they're only looking at a capital gain of half of that, $500,000.
Half of it,
And so
okay.
the tax would be on that.
Okay.
Now it kind of confuses the math with the fact that land constantly increases in value, right?
Yes.
And so it does, but it's the same concept. Whatever the gain is, that'll be half of it got stepped up at the first death, and the other half will be stepped up at the second death. But we're talking about something that's happening between the first death and while the survivors are still alive.
Yeah.
And so there will be a gain. Now, there is, in this kind of property, I don't know if it'll help, but you can get out of paying capital gains of $250,000 per person or $500 for a couple if you're selling the primary residence.
Okay.
If that's what they're selling.
If it's a primary residence, yeah.
Primary residence defined as where you live.
Yeah.
And all contiguous property. So
Right.
if you have a 10-acre lot and that's where your house sits and you live there, that's the primary residence, but it would also include, let's say you have 1,000 acres that shares a border with that. That would all be the primary residence. And so,
Okay.
so you can get out from under this capital gains to the tune of that much one time, and that would put a big dent in what they owe in gains.
Yeah, when I read this scenario here, I was thinking that there was a way that this one-time thing that, in other words, when I read that, I thought there's something around this that's not completely right.
I agree.
That's not completely right about it. I don't know. I'm not a tax expert, but I just think I remember if this is their primary resident and farm, then there's some rules that she could get around some of this.
That's right. I mean, the capital gain equation analysis we just did applies to all real estate being sold. But if it's a primary residence, it enjoys that special exception to get out of a big chunk of the capital gains.
Yeah.
Now, I think being a single, she's only going to get half of that, but I'm not entirely sure.
Okay.
I know you can do it twice as much if it's a married couple, but if you're married, if one's deceased, you're not married anymore.
Need to find a really, really good tax person.
Well, yeah.
Yeah. Somebody.
And there's different kinds of taxes too.
Yeah.
And not many people deal with just capital gains taxes, but a good tax person probably should. Good accountant should know how that works.
Yeah.
I don't know, so.
Yeah.
But and I don't think all the facts are there, but she's trying to get out of paying the capital gain, right?
Well, we're just talking about in general how it seems unfair, really, to.
Well, it's less than what they pay if he was still alive and they were selling it.
Yeah.
And now, if she has that exception to get out of, the only thing she can do is roll that money into another piece of property of equal or greater value. And
Yeah.
that's called a 1031 exchange, And basically, you're kicking the can down the road on the taxes. You're not gonna pay capital gain on it, but it's gonna get paid someday, you know.
Well, nothing in life is certain except death and taxes, evidently. That's what they say.
But if she needs to sell it, that's one thing, you know.
Yeah.
But if she doesn't need to sell it, if she just keeps it and gives it to her children at death, then all sins are cured because the children get that full step-up basis.
Yeah.
And to them, they can turn around and sell it the next day. There's no gain whatsoever because their basis is the same as the fair market value the day of death.
Right, right.
So that's a big advantage to them. But if you got to sell it, you got to sell it.
Yeah. All right. Well, let's see who's on the phone.
Either that or hang out until Trump gets rid of the capital gains tax.
Yeah.
Ties in with this, but with a different twist, and it's somebody in another state, and I'm just trying to understand here to explain to them. They have two houses. They have the woman, I won't go into detail how many there are, but the parents are both late 80s, early 90s. One is almost ready to die, she thinks, and they have got a trust. I don't know a lot, but let's just assume it's the right kind of trust. She said they have life estates in that trust. Now, does that mean that it's made over to them or to the trust? I've got another question. Let me go down here. And if it goes to the trust, there were other things like with the first house, like he was talking about how it's treated. It says, be sure you have formally inherited this because the other house is not their primary residence. It was left by a sister to a brother. And there were other things it mentioned, like for example, like, I was just trying to understand, would you need an asset protection? I mean, how would that change the dynamics of what he's talking about? I'm just trying to understand this. Does he understand the question?
I'm not sure.
I do not.
Well, how, if somebody makes a life estate, are they making it out to the trust or to the children? And does that affect what you're talking about now? It would be different from what you're talking about now.
Yeah, I think it's different.
I can address that.
Yeah, okay. All right.
All right, if we're talking about the life estate, you know, let's understand what a life estate is. A life estate is when you give property away and you say, let's say, okay, let's use you and Teresa. You say, you know, let's give our property away.
Yeah.
That way, if we give it away 5 years before we need care, it won't be in, they can't come and do anything with that.
Right, exactly.
So let's give it to our son. Just deed it to him. Love and affection, $10, and other good and valuable considerations. So essentially a gift, right?
Right.
But then you say, you know, wait a minute, or you go to a lawyer and the lawyer says, well, you know, if you give that to him, he owns it. And if he owns it and you want to continue living there, he can just, the day after he owns it, he can come and give you the boot. And he can, because it's his, you just gave him full ownership, right?
Right.
So what people will do, and this is an old common law form of action, it's been around forever, you deed the property and you retain for yourself the present possessory interest. Now, there's a lot of bundles of rights with land, but I want to talk about two of them that make it easier.
Yeah.
One is the present possessory interest. If you live there, occupy, and possess, okay?
Yeah.
Physically. You know,
Yeah.
you're not, the second one is the future interest.
Yeah.
Or that's called the remainderment. I don't know where the name came from, but I guess the remainder. And so when you do that, you're passing to your son the future interest, the remainder interest. You are reserving for yourself the present possessory interest, and it's got terms and conditions that you and or you and your wife can live there till the end of your life.
Yeah.
Okay. So and then at your death, then the life estate just expires worthless, and now the remainderment owns both the future interest, which you gave him in the first place, and the present possessory. They now own all the rights for the land.
Yeah.
So they do that so you can't, if somebody has a life estate, you can't kick them off. And that life estate is pretty strong. I mean, like if your son sells his land to some big industry that wants to develop that land for some reason, whoever buys it has to honor the life estate. They can't come kick you off.
Right,
Because
exactly.
that runs with the land. In other words, it's
Right.
like a covenant. And so that's why people do a life estate. But now, you can do a life estate with a trust. And here's a good example. I've had people say, at my death, this property, let's take a blended family and a remarriage, okay, and say both have their own children.
Yeah.
Now, they're living in a house, and the wife says, if I'm the first death, I want this, and I own this property. I want this to go to my kids, because that was always the plan before my first spouse passed away or whatever.
Yeah. Yeah.
So I want that distributed at the first death, but I want my new spouse to have a place to live for the rest of his life. So I'm going to deed it to my kids, and I'm going to reserve a life estate for him.
Yeah.
Okay. Now, that's not in the trust. It's in the trust now while they're alive, but at the second death, property leaves the trust and goes where it's supposed to go, right?
Right.
And in the trust it will say, deed to property, meaning the remainder interest to my children, but specifically reserving a life estate for my spouse.
Yeah.
Now, when you do a life estate, sometimes we put conditions in there, like as long as they're residing and possessing. Because
Yes.
if he moves off to Colorado, you don't want this house having a life estate that you can't do anything
Right.
about, and
Right.
nobody's really using it.
Right.
Or sometimes people say if they remarry, it expires, stuff
Right.
like that. You can put terms and conditions on it.
Sure.
And I advise you probably do that, because
Yeah.
the whole purpose of it is to, if they have a place to live if they're the second death.
Right. Right.
So that's the life estate, and that life estate is not really in the trust, but it can distribute the property and make that express reservation of the life estate. I'm not sure if that answers the question, but that's how the life estate would work, and that's how it would work with the trust.
Yeah. Well, it cleared some things up for me there. I mean, that actually makes sense.
And one other aspect of that is a lot of times when people do a trust, of course, we retitle their real estate to put it into the trust, right? So sometimes we'll have a piece of real estate and we'll see on there that grandma's been left the life estate, right? And so we'll say, is grandma still alive? And they say, yes, she's still there. So we can put that piece of property into the trust,
Right.
but we still have to honor the life estate. So what we're putting in is the remainder interest, because that's what the people own
Yes.
at that point. Well, actually, they own it all, but they've been stripped of the present possessory right. And so, but that will come to them at that person's death.
Right.
Now, just to go a little farther, and since we're on this subject, life estate is a weird animal when it comes to
Yes.
assets, because we deal a lot with assets and getting people eligible for 10 care, and that is, if you do that, let's say you give your property to your kid and you retain a life estate, the government puts value on that. I want to tell you how they do it.
Yeah.
If you go to Title 42, which is the Social Security Act, there's a table called the life estate table. It's got
Yes.
it's got three columns. First column is age.
Yep.
Second column is the remainder interest, which is the future interest, and the third
Right.
column is life estate interest. Okay?
Yes.
And if the first column age, it's just age all the way up to 119 or something.
Yep.
And then, as you go down every row, the two under remainder interest and life estate interest, every row is a fraction, out to 6 decimal places. Don't even ask
Yeah,
where that comes from.
unbelievable.
But anyway, but if you add those two decimals up, you get 1.
Yeah.
Okay. Now the life estate reduces in value with age. But
Yes.
here's how they put a value on it. They will go to your age when you gave it to the child.
Yeah.
So let's say it's a $100,000 gift, right?
Right.
The house is worth $100,000. Okay. And you were 65 when you gave it. They're going to go down to 65, go across. They're going to look at the numbers, and they're going to put value on what you retained, which was the life estate. So they're going to take the fraction that's under the life estate column, and multiply that decimal times the market value at the day of transfer, which in this case is $100,000.
Right.
And that number is going to hover right around 40%. And so what they're saying is you actually made a gift of $60,000, not the whole 100.
Right.
You retained the life estate, which we're valuing at 40,000.
Yeah.
Now, if you look at the life estate numbers as you go up, down the column and up in age, it gets smaller and smaller.
Right.
Sometimes, like back in 2022, when the price of land went crazy,
Yeah.
the one exceeded the other in the opposite direction.
Yeah.
The life estate got more valuable
Yeah.
with time,
Yeah.
which was really bizarre. But anyway,
Yeah.
and if you follow that, essentially, then when you die, that life estate is worthless. It has no value.
Yeah.
So, but the problem is sometimes during life it represents an asset that you have, and it's a countable asset.
Wow. Okay.
Now we can deal with it, but they assign a value to that. So,
Yes. And
I
that
hope that answers the question. Now,
that calculation is based on your calculated life expectancy or something like that.
well, that's not the actuarial table. There's one that says if you go to your age, it'll tell you how long you're going to live.
Yeah.
This one just is whatever your age is. Here's the life. It's only got those 3 columns.
Yeah.
I know the one you're talking about. The actuarial tables. There's a whole listing for male and a whole listing for female.
Right.
You go to your age. You go across there, and it tells you how many years you have.
Yeah.
It's like two decimal points.
Yeah.
And you know, I think at my age, I think we cross here something like 8.7 years or something, which is a fun thought to
You
think
don't want to
about.
look. You don't want to look at that table, really.
Again, it's
once
not
you get
that-
to a certain age, you don't want to look at that.
The government doesn't know how long you're gonna live. Those are, that's what they call, when we do a Medicaid compliant annuity, it has to be what we call actuarially sound.
Yeah.
Which means you can't have an annuity that exceeds your actuarial lifetime.
Yeah.
So if you're 90 years old, you can't have a 50-year annuity, you know what I mean?
Right.
Because it's gonna exceed your lifetime. Stuff, that's just, the actuarially means statistically, this is how long
Right.
people basically in your, 65-year-old people live, this is how long they live.
You know, it's amazing how much our world depends on statistics.
Yep.
In every arena, you know, it's applied all over the place. We use it in real estate all the time. So.
Yeah, I mean, it's an interesting science. I've taken some college courses in it. It's kind of it's kind of number heavy. It's big time number heavy.
Yeah. Yeah.
But yeah, I mean, it's not a look into the future, but it's a better guess into the future. Is all it really is.
A good guess and a better guess.
I mean, it's not a wild guess. You just pick something.
Yeah.
Pick it based on how. I mean, if that's the way things normally go, chances are they're going to go that way.
Yeah.
Anyway,
Yeah.
The chances are better they're going to go the way they've been going.
Yeah.
But it's certainly no guarantee because stuff happens all the time.
Yeah, it's like, you know, we make estimates on how valuable a piece of property may be before we sell it. We're trying to determine how to market what this property may. So we look at those kind of averages and numbers and square footages and compare, and you come up with what you think it may be worth, but you still have to figure out, is it really going to be worth that?
Every year for, I don't know, as far as I look back, 50, almost 100 years.
Yeah.
Stock market increases a little bit, I mean, a pretty big jump every October.
Yeah.
Okay, I'm not going to get into the reasons why because nobody really knows the reason why, and you don't have to know the reasons why. But if it's done that every year, every October for the last 100 years, what do you think the chances? Is it a good bet to make a buy or a sell this October based on the information?
Yeah.
I think that's definitely hedging the.
That's right.
It's helping the decision to do that. That's right. So, and that's what the same thing. But no, I'm trying to think. I think we answered the question because here's one thing I want to point out. And don't take this the way it sounds, but. You know, she said, I want to understand it so I can explain it to them. You know, you may not want to be the one explaining some of this stuff to somebody because, I mean, if you give them bad information, I don't think they can really do anything to you.
Yeah.
Because you can always say, hey, I'm not a lawyer. I don't, you know, but you don't want to give them bad information. It sounds like it's somebody they care enough about that she's asking questions.
Right.
So feel free to help explain it, but be sure to remember and qualify it anyway.
Yeah.
Or tell them they need to, you know, look into it just a little bit more.
Okay. All right. Well, we may well talk about it again, it looks like. So good morning.
Maybe we didn't get them all.
I don't explain it to them. I just say, this is the question I think you need to ask. In other words, I take what you say and say, for example, one of the questions that came up to me to tell her was, is this set up in any way that affects their being accepted to under Medicaid? Of course, she's going to be talking to somebody too. And another one would be, do I understand how it's set up as far as taxes? She can't change anything, but it sounds like she's trying to make major decisions without really understanding. Does that make sense? But I just want to clarify that. I'm not giving legal advice. I just tell her questions I would ask if it were me.
All right.
Understood.
Sounds good. Yep.
I was sort of going. I was pretty sure she said she wanted to explain it to them, but
Yeah.
she qualified that. I mean, that's a good idea. The first thing is it going to affect, you know, having this life estate? Will that affect getting eligible for TennCare? And the answer, it'll have an effect, but it's a fixable effect. In other words, when you retain a life estate where you live, okay, you can. That's treated like your primary residence, and that is an excluded asset. And the fact that it expires worthless at death keeps them from exercising state recovery on it. So there's a way to protect it from that. So the answer is no, it won't. If things are done right, it will not be an impediment to being eligible for their states. She said it was another state, and whatever that state's Medicaid is, it shouldn't be a problem.
Should. Good deal.
And again, you know, I mean, they do need to talk to some folks, especially if it's another state. You've heard me talk about the 50 bubbles inside the big bubble, but every state has got their own. Some are similar, but they have different rules. Now, the life estate, I'm sure, is probably pretty much universal because it's been around forever.
It has.
But how it's treated by Medicaid may not be.
Right.
So,
We run into the life estates every once in a while.
Sure. You should probably learn a lot.
Excuse me.
And you know, just to be maybe trivia.
Yeah.
Do you know that a life estate can be based on anybody's life, not yours?
I did know that.
I mean, you can say, I probably don't want to pick the former prince because of those problems, but you could say, I want, you know, my life estate is based on the King of England,
Yes.
or somebody else, anybody. You know, the mailman.
It
It's based on the mailman's
it
life.
doesn't have to be your life. It can be based on something
Now,
else's.
if you think about it, it seems kind of bizarre, but I can think of there'd be times when that might be a reason to do that.
Yeah.
But I've never seen it actually done. I know you can. I know in under a common law jurisprudence you can do it.
Yeah.
But I've not seen a life estate that was based on somebody else's life.
Yeah, but it's doable.
Well, it kind of is. When you say my wife and I, it's kind of based on whoever lives longest. So.
Yes.
But yeah.
Yeah.
No, but you sure can. You sure can. So.
Stan Pierchoski, everybody. By the way, the phone lines are open, 766-9393. If you have estate planning questions, and of course, wills and trust is his area of expertise.
I did forget to give the number in the beginning, didn't I?
Yeah, 766-9393 is
But
it.
that was your job, not mine.
Yeah, that's kind of my job. Kind of my job.
That's
yeah.
it. All right, so one thing I was going to mention was we had the big seminar not too long ago. We got a lot of folks that want to engage, and the very popular thing we do is this asset protection trust.
Yes.
The caller made some kind of reference to it, but and it's exactly that: protects your assets from your creditors. The creditor most people are worried about is long-term care,
Yeah.
and we do a lot of them. But occasionally I get the question, like when people realize, when I explain to you this is an irrevocable trust, sometimes that worries people. They think, well, I've always heard that if it's an irrevocable trust, you kind of want to stay away from it because you can never change it. You know, you can't do anything about it. The property's gone. You won't get to use it. And that's not exactly what it means. I want to talk about irrevocable trust.
Okay.
And I'm at a loss to explain where the name comes from because I think it's an unfortunate name. Because I want to tell you right now, and you'll probably tell me that's a bunch of legal double talk, but you can revoke an irrevocable trust. Okay?
Well, of course you can.
And so I don't know why they get the name, okay? But I've heard people, I was listening to a radio station or a TV station where somebody said, what's the difference? It was a talk show and they were saying, what is the difference between a revocable trust and an irrevocable trust? And the person said, well, I guess one's revocable and one's not. That is not the answer. You can revoke an irrevocable trust. Our trust code is very, very clear on how to do it.
Okay.
There's two things that define an irrevocable trust that I think it's best to remember what the two. One, you can revoke it, but you, the maker of the trust, cannot revoke it unilaterally, which means all by yourself. You need the beneficiary's permission.
Okay.
Because on an irrevocable trust, ownership vests with the beneficiaries as soon as you make the trust. So they have to be involved in the decision, but you can back out of it. And we have done that on several occasions. You can back out of an irrevocable trust. So it's revocable. You can also change it.
Okay.
I mean, even if we were going by name, it says irrevocable. It don't say you're unchangeable. It says, but you can change it. There's certain things you can change. I mean, like where property goes after death, who the trustees are. The trust that we do for asset protection, you can make those changes. Now, the change is made a different way, and it's made a different way if the creditor we're worried about is long-term care. But I'm not going to get into that because that is really confusing. So if you have one of those and you want me to change it, just let's just go with, I'll make the change. It's not just an amendment, it's a special way to do it. But only if you're worried about long-term care. If it's just regular creditors you're worried about, you don't have to do it that way. But you can modify it. So that's a misunderstanding. Like I said, I don't know, I think the irrevocable term applies more to the beneficiaries than it does to the makers of the trust.
Okay.
So anyway, so the other thing to remember is, in a revocable living trust, the maker of the trust is all three parties. You're the trustor, you're the trustee, the person that controls the property, and you're also the beneficiary, at least during your life.
Right.
So you're all three parties to this agreement. In the irrevocable trust we do, you're the maker of the trust, the trustor, and you can be the trustee, but you cannot be the beneficiary, which is what gives us the creditor protection we're trying to.
Yeah.
If you were the beneficiary, then you had access to the property of the trust, and then you don't get the protection of the property.
Right.
So those are two things to remember about an irrevocable trust that cause some confusion. And the second thing that came up that I wanted to mention that has come up in the last couple of weeks. It comes up all the time, but it seemed to come up 2 or 3 times in the last 2 weeks. And that is, if you make an irrevocable trust, like our asset protection trust, can you also be the trustee?
Yes.
And the answer is absolutely. There is no shortage of statutory law, case law, or treatises written on this topic, and the answer is you absolutely can be the trustee. Well, if you go on the internet, sometimes you'll hear about what they call a Medicaid Asset Protection Trust, and they'll say, you can do this, but you cannot be the trustee. Now that, you can be, but you don't have to be. It can be somebody else.
Yeah.
And sometimes somebody else is a better choice. In other words, if you want to do an asset protection trust, I'd say you and Teresa, you know, if you want to be the trustee, that's great. If you don't, you can name somebody else. But if you came to me and you're very advanced in years with a lot of health issues and what we're worried about is long-term care, it's probably not the best. You probably shouldn't be the trustee because, you know, you're starting to get a little more feeble mind, you know, especially if you have any kind of coming on dementia. You don't want to be the trustee of this. So there's reasons why you wouldn't be, but it's certainly not a have to be or you can't.
Yeah.
And then the question comes, well, if I'm, you know, if the idea is to protect this property by putting in trust,
Yeah.
and then I'm the trustee, can they come after the property of the trust if I, you know, if I owe, you know, like if we need if they want to come after me for long-term care costs, can
Right.
they get at the assets in the trust because I'm trustee over it? The answer is no. Trusteeship is a fiduciary duty. You have no ownership when you're the trustee.
Yeah.
Just like I get the same question from a little different perspective where people say, if a child says, if I'm trustee over my mom and dad's trust, and I get sued, can they get at mom and dad's property because I'm the trustee? The answer is no. There's no legal vehicle where that can happen. The fiduciary duty is, and so the courts have said, since there's a fiduciary duty over the property, but no ownership of the property,
Right.
then you can certainly be the trustee because you're not affecting, you know, because people say, if I'm the trustee, do I not have too much access to the property, which is the one thing we're trying to limit.
Right.
And the answer is, no, you don't have access to it at all. Access is ownership. What you have is you're the one who distributes property and puts it in or takes it out. So
Yeah.
you have the responsibility to deal with it, but you have zero ownership.
Right.
Reminds me of when I was in law school, we had a estate planning course. It was very short, and I remember I just paid attention enough to get through. But it wasn't very comprehensive at all. But we were talking about trust in our wills and trust class, and I remember the instructor saying something like, you know, he said, "Hey Stan, if I told you you were trustee over $10 million, you know, you start to get a smile on your face, and,
Yeah.
he looks at you and he shakes his head and said, you probably wouldn't be very happy because you have this responsibility and the obligation to deal with the $10 million. You don't get one thin dime of it. You have
boy.
no ownership in it.
Yeah.
And that's what the fiduciary duty is.
Right.
And that's what severs you from that property. So, I mean, if you're not the trustee, you don't have to worry about that. But if you are the trustee, don't worry about the fact that that's available to you because you're the trustee, because it's not. You
Yeah.
can only do what the trust says you can do, and the trust says you cannot exercise any kind of ownership over it. You just do what the trustor tells you to do with it, or you know, that's pretty
Yeah.
much your job.
Yeah.
You know, if you know, property gets put in it, it's vested with the trustee. That's what in the trust means. So
Yes.
you know,
Interesting.
So yeah, I wanted to talk about those things.
Yeah.
Those two things: irrevocability and the ability to be trustee or not. So
Wow.
but you can be the trustee.
Okay.
The only thing I would do is if I tell people that if one of you go into long-term care, I would probably suggest to you that we resign as trustees and reappoint before we apply. Now, I do that because a scenario, and this is the engineer in me, I think, that the scenario I could come up with that might be problematic.
Yeah.
It would be wrong, but 10 care is often wrong. And it's something I think they could probably come up with that we'd have to deal with, whereas if you just resign and reappoint, it would not come up at all.
Right.
So, that kind of thing. And I've never seen it come up. I mean, I think someday it might, but, you know, when you talk, you know, I guess if somebody that works for 10 care is listening and they want to call and talk to me, I hate to...
That would be nice.
I hate to beat up on them, but, and I can't say all, but some of them are very nice, but all of them have a limited understanding of how the rules are. Now, that strikes me odd when they're the people granting approval and stuff
And should
like
be
that.
the enforcers of the rules.
Well, they should know it to be able
At least know the
if you're
rules.
going to grant approval or deny approval, it seems like you should have an understanding of what the rules of approval, and the rules for approval are voluminous.
Yeah.
There's lots, and so, and they often make mistakes. And,
Wow.
I mean, we just got 2 approvals in the last week or two, which is great news. But we go through the approval, and when you get the approval, then somewhere in there it says what your patient liability is. So, okay, you're approved. Here's what you pay from now on, and we'll pick up the rest.
Yeah.
And what you pay from now on is basically your income.
Yeah.
So let's just say you get $1,000 of Social Security every month.
Yeah.
And you get approved for long-term care, which is costing $10,000 a month.
Right.
You'll say, okay, you're approved. So your patient liability is going to be this $1,000. You can take out like $70 for a
Right.
personal needs allowance, but all your income goes, and that's your patient liability. Then 10 care picks up the tab.
Yeah.
Whatever that is. If it's it's usually not the full 9,000, but it's the rest of it.
Right.
And so we got these 2 approvals, and in both of them, they botched up the patient liability. because both of them, we had a Medicaid compliant annuity, which you're roughly familiar with.
Yep.
And they included the annuity payment into the income, which is correct, except the annuity only survives during a period of penalty, and then it expires. And so what we had to do is file for, here's what normally happens, they do that a lot, so they don't understand the rule there, but we file a fair hearing, because that's how we can fix a mistake. So we file a fair hearing, but then we try to get them on the phone and say, look, here's what you did wrong, here's the liability.
Right.
We're pretty successful in resolving that prior to a hearing on that issue. So, but I mean, I think they should know that ahead of time and know what we're doing, know what to do.
Right.
I mean, again, I don't want to bash them. Maybe they don't get any training. I mean, I don't know. Maybe it's not a very good. Maybe it's not a fun job to have. I know they have a lot of high attrition. People come and go like crazy, but whatever. It's just part of it. But if you're trying to do it on your own as an individual, you're going to be extremely frustrated.
Those positions, are they not state positions?
They are. They are state of Tennessee positions. They have people in the county that deal with it, but it is a state position. Bureau of TennCare is a state agency.
That's what I thought.
Well, anything in the county is a state agency. County is a subset of state, so. City, subset of county.
Okay.
So yeah, they're all Tennessee jobs in a way.
So it's a state held position, I guess I should say, state paid position. It looks like it would be a good position. You'd think that they wouldn't be so much turnover.
Well, I don't know, but I'm not a fly on the wall there, so I don't know. But I don't think we've ever got the same person twice. Now, when it comes to some of the TennCare attorneys, yes, we get some of the same attorneys over whenever you deal with this area.
Right.
But the caseworkers, which is the first line of people you're going to deal with,
right,
it's kind of when you go to the bank, the first people you talk to are the tellers.
Right.
And if you want to talk to the loan officer, when you get a notch up, things go a little smoother.
Yeah.
But even there, it surprises me sometimes the things they dig their heels in. And I come right out and tell them, I say, look, this isn't the hill you want to die on. We're going to win this. I'll explain it to you. We'll go through it. I'll show you exactly how it works if you want to listen to me. I said, but don't fight this battle. You cannot win. You cannot win.
Yeah.
And sometimes they do anyway, and they don't. They don't win. But a lot of times when you get to the attorney level, because they're the ones who are going to be at the hearing.
Okay.
And so they're a little more receptive to the thought process.
Sure.
Some have been there forever and don't want to hear a word you have to say. Like, I've been doing this for 30 years, don't tell me how it works.
Yeah.
I say, well, you're wrong, and you want me to tell it in court, and we tell the judge, and it's not like I get up and argue and just say, this is what I think, Judge. I don't do that at all. I said, Judge, here's the application. Here's the income. Here's the Medicaid compliant annuity we got that created a penalty period, and the annuity pays through the penalty period, and at the end of the penalty period, TennCare has granted approval saying they're going to pay the balance. And now here's how you calculate the patient liability, and it cannot include, and specifically says right here in the third sentence of this paragraph that it doesn't include the Medicaid compliant annuity because TennCare is not paying during the penalty period, you are.
Right.
I said, here's how it should have been calculated, and here's the statute that says how it calculated, and here's what the number would have done if you did it that way. They did it wrong. I've appealed it. I want you to rule that my way is right.
Yeah.
And I'm successful. I've been successful 100% of the time.
Yeah.
100% of the time.
Yeah.
That's a pretty
That's a pretty good record.
I can't guarantee, people say, I say I can't guarantee a result. I'm not allowed. The laws of professional ethics say you can't guarantee a result. Because really you can't, right?
That's true. You can't.
But I can talk about my history, and I've never failed to get anybody eligible.
Yeah.
A couple that hung out there, like the one I used to talk about, it took 1 year and 4 months, but we got there.
Yeah.
I've never failed to get anybody eligible, and I've never lost a fair hearing. So, I mean, that's my track record. Statistically, it should probably continue that.
We got good statistics to go by.
We're in good shape. So, but I was just getting at the, when you deal with folks. So my point is, if you're going to try and do something like this on your own, because a lot of people say, I'm not going to hire an attorney. I just want to do it myself. You're going to run into all the people that don't get it very well. I don't want to say incompetence, but people that just don't. You're going to run into the same people we run into.
Right.
And you're going to get the same ridiculous answers from them, and the same poor cases going to a hearing. But here's the thing: how are you going to argue with them? How are you going to stand up in a fair hearing if you don't understand what they did wrong and what they should have done that was right?
Yes.
That's how you win a hearing. You win there and all of it backed up by the authority that supports your position. You're never going to say, well, I think this, and well, she doesn't have much money, so I think they should have approved her. I mean, none of that has anything to do with anything. When you get into court, it's the rules. What the rules say, It either allows it or it doesn't allow it. And so
Yeah.
but you got to know them, don't make the argument.
Yeah. I think one of the most interesting things you told, and it's been a while back, you were telling about a lady that evidently was trying to help somebody with this and they filled out the form, and they were the person that they named on there that was helping fill out the form, and then they had to go to an appeal, but they didn't have something else signed and they wouldn't even listen to her.
You know, I'm going to tell that story again.
Tell it.
That was a good one because
it's very good.
Because that story,
it's a great example of how this works.
That story boiled my blood. And
Yeah.
that was the first case where I inherited a do-it-yourself application.
Yeah.
And it was a little cumbersome, but I've done several since, and I often say, I'm going to stop inheriting these things because they're full of mistakes.
Yeah.
And I can get a good result, but I could have got a whole lot better one if I'd have done it in the first place.
Yeah.
But then I think to myself, well, these people
They need help.
They're in up to their neck.
Yeah, they
in
need help.
quicksand. So I continue to do it.
Yeah.
But we had a gal. She was doing her dad's TennCare thing, and she filed the application. TennCare gladly accepted it.
Yeah.
And because they allow you to be what is called an assisting person.
Yes.
Or a helping person.
A helping person.
I mean, so we have to define what's a helping person, okay? As a person, somebody can help you file the application, okay? And then there's several other names in the application. She filed the application. They took 3 months to look at it like they do. Then they started asking for things, and she sent it in because they recognized. She also signed the form called TennCare Authorized Representative, meaning, okay, we can talk to you about your dad's situation.
Yep. Yep. That's the part that got
it. So she was. So she did that. Then they denied. And she said, well, I'm going to appeal this. Of course, she didn't really understand why he was denied, but she on the appeal. So the appeal was telephonic. It was some years ago. I don't know if it was during COVID or not, but they still do them mostly telephonic.
Yeah.
And so they get the call. They're on there. The judge is there. The TennCare attorney is there. She's there. They get past the formalities, you know, the announcement of the case and stuff like that. And so they say, okay, you know, the appellant makes an opening argument, right? She started to talk. She didn't get 2 sentences in, and the TennCare attorney interrupted and said, she cannot be representing her father at this hearing. She doesn't have power of attorney. And I think she got out when the judge asked her something, said, do you have a power of attorney to represent your father? She says, no, but I filed the application, and they accepted that. And it's like, well, that's a different thing.
Yeah. Yeah.
That's a different thing. And here's the part that made me mad. That's the first she ever heard of it. And when they did that, they said, you know, she can't do this. So, Judge, we want default judgment in our favor because there's nothing she can say. She cannot speak on his behalf at all. And so it's almost like the patient's here in absentia, and so we want a default judgment in our favor. And the judge, being a judge, thank goodness, said, you know, I think that's, I don't know what he thought, but I think it's a little low down to take that position. But
Yeah.
so I think that's a little bit more unfair than I would like to see this person at. But again, the person doing it is held to the standard of knowing what you're doing.
Yeah.
You don't get cut a bunch of slack because you're a layman and don't understand the rules.
Right.
Because if you say, okay, you don't understand the rules, let me explain to you what you should have done. Well, now you're working a tort against your opponent, right? Because, but you know, so. But what he did was he gave her 30 days for her to deal with that.
Okay.
And she started saying, well, my dad's so far along in dementia, he can't give me a power of attorney. The judge just kind of said, you know, I'm going to give you 30 days to deal with it. So what we did is when she came to me, I said, well, we'll do a conservatorship. I've never done one in 30 days. Got that one done in 28.
Wow.
And so we showed up at the hearing, and we were okay at that point. But I just thought it was kind of a low-down thing. I mean, granted, they have no obligation to advise her that she's lacking something before the hearing.
Yeah.
But you know, when you talk to them on the phone, I mean, there's a sense of fair play that we're always bound by.
What's frustrating about that to me, just listening to that, is that we have our paid-for state government people who are supposed to be a help to us, and yet something like that, you hear a story like that, and they're not helping at all. They're just using the system to get through it and spit you out.
It's still an adversarial proceeding.
Yeah.
So their job is not to help you out. Their job, here's a good way to explain it. Your job is to get TennCare to pay as much as they can.
Yeah.
Their job is to get you to pay as much as they can, and TennCare as least as they can.
Yeah.
So that's the goal, and that's where the rule. And now the rules come into play. And
you know, I guess I would say, okay, I understand what you're saying to me, but in my head, I would think that the people they put in place in those positions would be there to help you put into play the proper thing for your certain circumstance, no matter what it is.
I would think, well, the caseworkers do that to some extent, but.
Yeah, yeah. Rather than try to deny you, though, it looks to me like they would say, "Well, here's what you can do, and this is what is right for you."
But if you ask them any kind of questions that have any meat to it, they're always going to pull the I don't give legal advice card. You know, they say, I can't tell you what to do, what not to do, and that's true. So unfortunately, if you try to do this yourself, you are seriously disadvantaged before you even do the first thing.
Yeah, which brings us to the real whole reason for our program here is to help and advise people to prepare ahead of time for this.
Yeah.
And that's what your practice is all about.
That's right. I mean, we're talking about people who haven't done anything ahead of time, like the Asset Protection Trust, and you end up in care, what we call crisis.
Right.
You're already there, we're dealing with it. When you do the Asset Protection Trust, you're actually getting yourself prepared for being eligible for TennCare years in advance.
Right.
And all your big ticket items like the real estate that's in the trust is all out of the equation. When you have to fill out the application and say, tell us about your countable assets, everything in the trust is a non-countable asset. You don't even have to list it.
And it's protected.
And if they ask about, well, it's protected because it's not used in the eligibility equation. So
Sure.
it's not something they go, and it's protected from estate recovery, which is how they go after property after death. So,
Yeah.
It works like a champ. I mean, I've done enough of them to see them mature and go to TennCare, and they always ask for it, and when they get it, I know exactly what they're looking for, and I know exactly where in the trust they're looking for it. They're looking for this access to principal concept, and it's
Absolutely.
not. You won't find it in mine. It's not there.
Yeah.
Because I read the court cases out of other states, because there's not that many from Tennessee on this, but I've read those, but I read cases from other states that have similar rules.
Right.
And it's just perfectly clear what has to be in this trust to make it work. The courts have given us the answers to the question. They say as long as the trust says that you, the trustor, have no access to principal, and the people, we talk about giving property to your heirs who can turn around and use it on your behalf.
Yeah.
As long as those people are not obligated to turn around and use it on your behalf, the courts have said we will uphold creditor protection.
Yeah.
So don't do something that does either of those two. In other words, let's do what the winners do and not do what the losers do. When you read a court case, if you read a court case and the guy that's on appeal in the court just seriously slaps him down and loses the case miserably, right?
Yeah.
There's a lot of information to glean from that. Don't do what he did. Understand what he did wrong and don't do that.
Yeah.
When you get a case where they say, hey, you guys are, your argument won't stand. I'm going to rule that this person should be eligible. Because you can glean the information from that too.
Right.
So when you read these court cases and study the law, you learn what will work when you get to court.
Yeah.
Now, I approach every case like I'm going to end up arguing it to court, but not that many go there. Right. But if I take that position of correctness, when I get to court, I'm going to say, you know what? The only words coming out of my mouth when I get to court is statutory law, and the rules of procedure. That's all that's coming out of my mouth, and I'll win every time when I do that.
Yeah.
So but if I take that position, that's what makes us so successful. Because we file an application. If I file an application, I'm not filing it until all the answers on there can be answered to come up with a result of eligibility.
Right.
So in your application, if you've got $50,000 in the bank, I'm not sending in an application saying you got $50,000 in the bank, because it doesn't take a PhD to figure out they're going to deny it for being over-resourced, right? Right. And that's what happens when people do it, okay? And then where the nursing home does it for you. Now, so what we're going to do is we're going to modify that $50,000 to a non-countable asset, which is one of the many, many options we can use.
Sure.
And once it's not $50,000 of countable assets, now we'll file the application, because now we're eligible, and they won't find anything wrong with it. And if they do find something wrong with it, we know it's an inappropriate denial because they are eligible. And
right.
It works very well for us. So, anyway.
You've been doing it, and you've been doing it.
That brings us closer to the end of the hour, and I did want to review the seminar coming up again.
Yeah, what do you got?
Like I said, from the last seminar, we're doing quite a few of those asset protection trusts. That's very popular among people because it is a solution to this problem we talk about, okay? But it's the only solution to this problem. Anyway, we have this seminar that we do. We call it Wills, Trust in the Nursing Home. And we're doing that again March the 28th, which is a Saturday. When we do Saturday seminars, they're at 10 o'clock in the morning. It's going to be right here at the WLX radio station in the back of the building. This building used to be a bowling alley. It's a long building. And in the back, there's a set of double doors. There's no sign there. They call it the Country Cafe, but don't come expecting to eat lunch because it's not that kind of cafe. I don't know why it's just a name. But it is a big room where they do picking and grinning on Friday nights and dancing and
yeah.
So they've got a lot of room. But I often tell people, if you find the radio station, don't come in the front, because that's gonna be locked up, because that's the radio station.
Right.
But if in the parking lot, there's a set of double doors at the back of the building, just come on in that set, that's where we are.
Back behind, kind of behind the radio station doors.
And
back
if you're, it's the same building, but it's back there. If you're really lost, look for this 350-foot tower.
there. Right.
Go to where it touches the ground, and come in those doors.
That is right.
That's about, that's pretty
You
neat.
can see that from anywhere in Lawrenceburg.
That's right, that's the tallest thing they have, it's pretty cool. So.
Yeah, pretty neat.
But anyway, if you want to talk about any of this, or get RSVP'd, or you got some other kind of question, or the many different things we do in estate planning, call my office at Pierchoski Estate Law, Pierchoski Elder Law. The telephone number is 931-363-7222, or you can go to estateplanstand.com and you can ask a question by email, look at the calendar, see where we're going to be. We're at a new location. We moved, but we only moved 2 blocks.
Yeah.
You can see one from the other, essentially. But we're at 304 West Jefferson, so we're just 1 block off the square in Pulaski. But
Okay.
it's a nice little place where we really, it wasn't hard to get used to. It's bigger, we got more space.
Is that the street there, what is it, the southwest corner street going out southwest there? The hardware
It
stores
would
on
be
the corner?
the northwest corner.
Northwest corner?
Yeah.
Okay, all right, so I got
There's right across Jefferson Street is a H&R Block.
Okay.
And then across 3rd Street is the Baptist Church and that big playground they have.
Yeah, and of course you're near the college.
Yes, all right. As a matter of fact, I've got an intern.
Yeah.
I'm doing an internship with me from the college.
Yeah, yeah. Beautiful area over there, beautiful town.
Yeah, it's nice.
And,
Yeah, give us a call, 931-363-7222. Come to a seminar, ask all the questions you want. Real quick, at the theater, I'm directing 1776. It's a May performance. I'll give you the dates here.
awesome, I wanna come see that. I like history anyway, so.
We have 1 role still open. It's like a one-liner. If you don't want to speak too much,
Sounds like me.
It's like a one-liner, and if you don't like singing, the only singing that person does is in a group. But you
okay.
don't even have to participate.
All right. Very good. Stan Pierchoski, everybody, Pierchoski Estate Law. Check him out online too at estateplanstand.com. And the phone number to his office, 363-7222. Good
Always
to see
a
you,
pleasure.
buddy.
Always
Thank you,
a
man. See you next time.
This is WDXE.
Close.
Just a hair dead air. Well, if you were Butch Menifee, you'd have a